G'day everyone, and welcome to topic 11 of Laws 11062 Contracts B. My name's Anthony Marinac, and this is the penultimate lecture in your journey along the river of contracts. This is the 23rd out of 24 lectures for those of you who've done Contracts A and Contracts B with me. We are almost there. With this lecture, we finish up our discussion of remedies. So we've started at the start with the formation of contracts, then we've looked at their interpretation, then we've looked at vitiation, then we've looked at termination. This week we finish up with remedies, and then next week we'll finish up the entire course by looking at international aspects of contract law. Now let's refresh a little bit before we push on with this week's material about the Australian consumer law. The Australian consumer law is only a couple of years old, and it was born of the fact that all of the states and territories had their own sale of goods type legislation, and all of the states and territories had their own consumer protection type legislation, and then on top of that the Commonwealth had the Trade Practices Act, and the Trade Practices Act applied to corporations because under Section 51 of the Constitution, the Commonwealth gets to regulate corporations. The thing is, of course, that in the modern world, almost all of trade and commerce involves corporations. So what we really needed was one regulatory regime to work right across Australia, and that's what the Australian consumer law is all about. Did away with the Trade Practices Act, did away with all the state and territory sale of goods and consumer legislation, well, more or less did away with them all, and instead we've got the Australian consumer law, which sits as a piece of Commonwealth legislation, and which then the states and territories all pick up on. So it really is a progressive decision that was made by the governments of the states and territories and the Commonwealth government, and really has made the world of contract students a lot more easy to understand as well. Now, when we looked at Contracts A, we looked at some of the effect, particularly the consumer effect of the Australian consumer law. And we looked at things like terms that get applied to contracts, consumer guarantees, and we looked at unfair terms in standard form consumer contracts. This week we're going to have a look at what happens when those things are breached. Okay, so we looked at them last in the context of the Australian consumer law creating obligations. This week we're going to say, well, what happens when one party fails to meet those obligations? What's the result? Let's push on and have a look. What are we going to look at this week? We're going to start with unfair terms in standard form contracts. So we shouldn't need to tell you all what an unfair term in a standard form contract actually is. We'll probably revise it a little bit, but you should be pretty familiar with that concept now. We'll look at what happens when there is an unfair term in a standard form contract. We'll then spend quite a bit of time looking at consumer guarantees because they're a little bit more complicated. And we'll ask what happens when one of these statutory consumer guarantees is breached. Now, beyond that, there are general powers which are given to the courts under the Australian consumer law, and these relate to all sorts of breaches of the Australian consumer law, which is a much more extensive piece of legislation than we're going to see in the course of these couple of lectures. So we'll have a look at some of those general remedies, and in particular one of the things that we're going to focus on is the fact that the Australian consumer law allows a far broader range of parties to actually approach the court for remedies than the contract law ever would. Now, if you think about this in terms of privity, right? Remember privity, week 12 in Contracts A? What this amounts to is the Australian consumer law allowing parties which are not privy to the contract to enforce the contract anyway. Now that's just about revolutionary, don't you reckon? Very interesting to see how it works. So let's push on. We're going to start with unfair terms in standard form contracts. And let me tell you, if you're facing an unfair term in a standard form contract, you are not the big bad wolf. You are Little Red Riding Hood, hoping that the big bad wolf doesn't eat you. What do we mean by by unfair terms in standard form contracts? Well, you should be able to tell me pretty much what we mean by unfair terms in standard form contracts. But let's revise anyway. To be unfair, a court's going to consider whether the term creates significant imbalance in the rights and obligations of parties, whether the term is reasonably necessary to protect the legitimate interests of the party imposing the term. Remember, that's the train station gym case. Whether the term causes a detriment to the consumer, because if the term causes no detriment to the consumer, then the ACL is perfectly happy with it. And finally, whether the term relates to the main subject matter of the contract or to the upfront price, because if the term relates to one of those two things, well, the term's likely to be regarded as valid. So what happens if there's an unfair term in a standard form contract and none of those exceptions apply? You can't say, for instance, that it is reasonably necessary to protect the legitimate interests. You can't say that it relates to the main subject matter or the upfront price. It definitely creates a detriment for the consumer. It creates a significant imbalance in rights and obligations in favour of the commercial entity and against the consumer. What happens to that term? Well, the legislation says that that term is void. So the legislation says that term is void. If you answer the question in an examination and you say the term is void, you'll be correct and you'll get the marks. But if you want to go that little step further, let's think about this conceptually. Remember way back when, in Contracts A, I think it may have even been something like the second lecture, we first encountered the idea of capacity to contract. And we learned in that lecture the difference between void and voidable. Now, a contract is voidable if the vulnerable party can decide whether to go ahead with it or not. In essence, I would say that unfair terms in standard form contracts are voidable. And the reason they are voidable is because the consumer has the choice. The consumer can go ahead with the contract if they wish, or the consumer can choose to refuse to abide by that unfair term, in which case the law will protect them. The only time that this is not the case is if we get the consumer authorities taking action on behalf of consumers as a whole. So, for instance, if we think about the train station gym case, as soon as the court decides that some aspects of that contract represent unfair terms and are void, well, those terms are void for everyone who's under those contracts. But if we're just talking about a single litigant, really, if you think about it, that single litigant's always got an option, haven't they? They can either just accept the contract, in which case they're never going to go near the courts and the contract will continue on and probably be discharged by performance. Or alternatively, they can go to the courts and have the term declared void. Now, to my mind, that makes the term voidable. Now, let's stop arguing for a moment about void and voidable, and let's assume that in this case, the term has been found to be void. It's been looked at by the court. The court has said, yeah, this is an unfair term, not going to enforce it. Term is void. What happens to the rest of the contract? Because it may be that a particular term is void, but we still want the rest of the contract. We still want the rest of the contract to continue operating. The court will ask the question, can the term sensibly be severed? Authority for the court to do this comes from section 23, subsection 2 of the Australian Consumer Law, which says the contract continues to bind the parties if it is capable of operating without the unfair term. Now, the example that I've given in the notes there is a great example to look at. Is Director of Consumer Affairs and AAPT. That's the telecommunications company. Now, the medium neutral citation for this case is 2006. It's the Victorian Consumer and Administrative Tribunal, case number 1493, and you'll find it on Ostley. You should also remember this case because we did have a look at it in contracts A. And there were a range of clauses that were found by the court to be unfair in the AAPT contract. However, none of those clauses were really critical to the performance of the main aspects of the contract. Have a look at the dot points I put there in the notes. There was a clause that allowed AAPT but not the consumer to change any part of the contract. A clause that allowed AAPT to charge reconnection fees. Clause which allowed AAPT to terminate the agreement, and a clause which allowed AAPT to change the terms of service. Now, if you got rid of those, none of those stop the fundamental contract from going ahead. The fundamental contract was, I will provide AAPT with money, and AAPT will provide me with a telecommunications service. If we strike out those four clauses, it's still perfectly possible for AAPT to provide me with a telecommunications service. It just means they can't change the contract unilaterally. They can't charge me reconnection fees under all circumstances. They can't immediately terminate the contract without having decent reasons for it. And they can't change terms of service for me if I'm a prepaid customer. None of that stops the contract from going ahead. So in this case, those void terms would be regarded as being severable from the rest of the contract. You just strike a big fat black line through them and say, once we've done that, once we've gotten rid of them, can the contract continue to operate? Can it sensibly continue to operate and look something like it would have if this dispute had never occurred? And the answer is yes. So in that case, the contracts weren't void, just the terms. What if that's not the case? If the unfair term is so central to the performance of the contract that you really can't operate the contract without that unfair term being in place, well, the bottom line is then the contract is terminated. If the unfair term is not severable, then the contract will be terminated. Let's have a look now at consumer guarantees. Remember the consumer guarantees, there were bunches of them. And I'm not going to take up time in the brief time we have available to us in this lecture, but there were a bunch of them. They relate to both goods and services, and they really relate to two areas. One is free title, and the other one is what you might describe as quality and fitness for purpose. And then all of that is broken down into a range of specific consumer guarantees. Now, in order to work out what happens in a case where there's a consumer guarantee that has been breached, we start by looking at the nature of the breach. And what we're asking ourselves in relation to the breach is this a major failure or is it a minor failure? And you'll see there that there's another definition of an epic failure. Epic failures have nothing to do with contract law. They have to do with the creation of internet memes that make people like me laugh. Forgetting about epic failures, we ask, is it a major failure? How do we tell? How do we tell whether the failure to comply with a consumer guarantee is a major failure? Well, we ask the question, would a reasonable customer have acquired the goods if they had known of the failure? If the answer to that question is no, then you've got a major failure. So for instance, let's say somebody purchases a motor vehicle. And they purchase the motor vehicle assuming that the engine of the motor vehicle is going to produce a certain amount of horsepower. And in fact, it produces fractionally less, say 1% less horsepower than what they're anticipating. Is that a major failure? Would a reasonable customer, now remember we're talking reasonable, so this is an objective test, would a reasonable customer have still acquired that car even if they knew they were only getting it 99% of the stated horsepower and not 100%? I think they probably would have. On the other hand, let's say we purchased a motor vehicle and the brakes were ineffective. And when I say ineffective, I mean they weren't working at all. You've got no brakes. Would a reasonable customer buy a car with no brakes? Absolutely not. So in that case, we're talking about a major failure. There are a few more questions we can ask to identify a major failure. The second one talks about whether the goods are as they were described, either described in advertising or described at the point of sale or described by the presentation of samples or a display model. If you believe that you're buying one thing and you're actually buying something completely, turns out you're buying something completely different, well then that would be a major failure. If the description of the goods that enticed you into the contract turns out to be a lie, turns out to be an extension of the truth, and you would not have acquired the goods if you'd known the truth, well, you got a major failure. Same with goods being substantially unfit for purpose or substantially unsafe. Any of those things would lead a reasonable consumer to say, I would not have acquired the goods if I had known of this failure. As a result, we're talking about a major failure. If we do have a major failure, I really do love those epic fail type memes. If we do have a major failure, what can the consumer do? Well, the first and most obvious thing the consumer can do is reject the goods. In other words, you take it back and you say, this is not what I was purchasing. This is not what I am prepared to accept. I do not accept this product as being a proper product satisfying or discharging your obligations under the contract. You were obligated to provide me with a car that had brakes. You have failed to do so. This is not a car that have brakes, therefore I do not accept it as discharging your half of the contract. Take it back. But you can do more than that. You can do more than just reject the goods. You can then actually decide to keep the goods and recover compensation. So let's say we've got this car with no brakes. We say, okay, the sticker value for this car is $45,000. The value of a car with no brakes is $40,000 because it's going to cost me $5,000 to get the brakes repaired, to get the brakes to a condition where the car is roadworthy. Therefore, I want to keep this car, but I want $5,000 compensation because what you have given me is a car worth $40,000 and I've paid you $45,000. Problem is, of course, that if that's the way you go ahead with it, then there's always going to be difficulties between the buyer and the seller as to how we actually value the goods that are subject to the major failure. How does someone tell what the value of the brake system is? Sure, you could go for that cost of rectification or repair, but that's not really the same as saying this is what the diminished value is. Let's say you were buying a diamond, and you're buying a diamond that was supposed to be 1.1 carats, and you eventually found out when it turned out that it was only 1.05 carats. Now, under those circumstances, you could well say, no, I'll take this diamond, but I'm not paying at the same weight as I would have paid if it was 1.1 carats. Under those circumstances, you'd think you could pretty easily work out what the actual value of the diamond was. However, under most circumstances, I reckon the customer's main course of action, if the failure is major, is always going to be to reject the goods. What if the failure is not major? Well, if the failure is not major, then there's a few different options that are available to both the consumer and to the retailer. We look at two different types of failures. The first of failures relating to the title. Now you remember about the consumer guarantee relating to title. We discussed this in Contracts A. Basically, if you're going to sell something to someone, you have to own it first. Or if you don't own it, you have to somehow have acquired the right to sell it. So, for instance, an auctioneer might not own the thing that they're selling, but they will have acquired the right to sell it on behalf of the person who does actually own it. Now, if somebody sells something to you and there's a problem with the title, they have a few options. The first is they could cure the defect in the title. So if I'm selling, let's say I'm selling an antique clock to you, and after I've sold the antique clock to you, someone else comes along and says, hey, that clock was stolen from me. I own that clock. Well, one of the things that I could do is cure the defect in the title by paying that person. If I turned around and said to them, look, I didn't know that this was stolen. What if I paid you $1,000 for this antique clock? And the person says, geez, I thought it was worth $35. It came to me from my aunt. Yeah, okay, I'll take the grand. And they agree to pass title to the seller. The seller then passes title to the buyer. The defect is cured and everyone's happy. Another option would be to replace the goods with identical goods where those identical goods didn't have any problem with title. So let's say you go into a furniture shop and you see a desk that you think looks awesome. You want to buy it. You do buy it. And the salesperson in the store who's selling it to you doesn't notice that there's already a sold sticker on it. At that point, the shop can't sell it to you. They've already sold it to someone else. They no longer have title to that desk. They give you a call a couple of hours later and they say, look, you know that desk that you bought that we were going to have delivered to you tomorrow? Turns out that desk had already been sold. However, we can provide you with an identical desk. We're just having it shipped in from the factory. Is that okay? And the answer to that, of course, has got to be yes, because they're replacing the goods with identical goods where there's no problem with the title. Finally, the bottom line is when nothing else will work, it's still open for the seller to refund the sale price. Okay, so they'll say, look, we shouldn't have gone ahead with that contract. We didn't have title, Nemo DAT and all of that sort of stuff. So, look, we're just going to refund you the money. Now, if the failure doesn't relate to title, and you suspect that most of the time the failure is not going to relate to title, the seller really has three options: repair, replace, or refund. Now, most of you, or some of you might remember that in the Australian Consumer Law lecture that I gave for Contracts A, I talked about my heart rate monitor watch, which had been sold to me on the basis that I'd be able to take it into the water. First time I took it into the water, it immediately stopped operating. Now, when I took it back to the store in question, I said to them, don't really mind how you sort this out, but you have to sort it out one way or another. They had three options at that point. They could have looked at the watch and said, oh, you know what, we can repair this, we can fix this, and so leave it with us for a week, and for a week and we'll be fine. They could have replaced. So they could have said, okay, well, look, here's another one. Hope it works out better for you. Only thing is, repair and replace in that situation probably wouldn't have been that effective, would they? Because we now know that this watch is not waterproof. So it's not going to meet the purpose that I explained when I first purchased the watch. Under those circumstances, the third option available is refund. So if you go in to a retailer as a consumer with a product that you're no longer happy with, ultimately they've got three options open to them. They can repair, they can replace, or they can refund. remembering always that we're talking here about a situation where the failure is not major. So that's how they deal with breaches of the consumer guarantees. The Australian consumer law, however, is a lot broader than the sections we've pulled out of it. And the reason that we've pulled out these sections is to provide you with an overview from the perspective of contract law. The ACL, however, has a much broader compass, and we could probably run a course, to be honest, on the Australian consumer law on its own. I do want to take you through a few bits and pieces out of the Australian consumer law just to give you a bit of a broader understanding, because there are a bunch of other remedies which are available to courts applying the ACL, which actually makes the Australian consumer law a really strong bit of legislation. The first one is pecuniary penalties. See, the Australian consumer law contains offences. Now, these are not criminal offences in the usual sense of the word. These are offences against the Australian consumer law. Now, a tribunal applying the Australian consumer law is therefore able to impose penalties for breaches of those offences. And one of the penalties they can apply is pecuniary penalties. In other words, financial penalties, the payment of fines. As you can see, that's a potentially very strong power for the courts to hold in relation to any breach of the Australian consumer law. But it's not an at-large power. There actually has to be a breach of an offence under the Australian consumer law. And the offence will also set out the maximum pecuniary penalty that can be applied. Second thing that the consumer law can do is set out compensation. In fact, the way that it works is that compensation has to be paid before the pecuniary penalty is paid, because the whole idea is to protect the consumer. So you don't want to run a company into bankruptcy by making them pay the pecuniary penalty and then find that there's no money left over to pay compensation to consumers. Compensation can be paid for a really broad range of types of harm, particularly in relation to harm caused by safety defects. So if somebody sells you a product which is unsafe, the Australian consumer law provides you with the opportunity to obtain a bunch of different financial compensation. You can be compensated for loss or damage due to the defects, and in particular we're talking about the loss or damage of the product itself. You can get compensation for injuries caused. You can get compensation for loss and damage of things that are not the item that was purchased. You can get compensated for damage that's caused by the dangerous goods to third parties or to their goods. You can get damage for destruction of other goods. If you've got an electrical item that bursts into flame and sets your house on fire, you can get compensation for the house and everything in it. And of course, having said that, that obviously means that you can also get compensation for the destruction of real property. So if a faulty iron results in your house burning down, you will get compensation, not only for the iron, but also for the house that's burnt down and for everything else that's in it. In reality, of course, the likelihood is that your insurance company will pay the claim, and that your insurance company will go after the company in the ACL. Now, who's liable? Who's liable? Because your contract, of course, when you purchase, your contract is with the retailer. So if you buy an unsafe product from the retailer, and then you become entitled to compensation because there's been harm caused by that product, does that mean you go back to the retailer and you try and get them to pay the compensation? Well, no. The way it works under the ACL is that the action lies against the manufacturer of the goods, not against the retailer. The second thing is the Australian Consumer Law contains a general damages provision. Now, last week we learned all about damages under the common law. Well, damages under the ACL behave pretty much the same way. So what you've got here essentially is a statutory authority as opposed to a common law authority for the imposition of general damages. All of those types of remedy are really more likely to happen when you have a single individual who's taking on a company because of a single set of circumstances. However, one of the most potent aspects of the ACL is that representative actions can be taken, in particular by consumer affairs departments within states and territories. They can take representative action on behalf of an entire class of consumers. This is a fantastic power because it means that you're not relying on David and Goliath situations. You're not relying on a single individual consumer to be prepared to put at risk all of the financial resources that must be put at risk in order to pursue this type of legal action. Regulators under the ACL can also obtain what are called enforceable undertakings. Enforceable undertakings are fantastic. These are incredibly useful tools or remedies under the ACL because it's basically an agreement. So your consumer affairs regulator comes to a company and says, you've been doing this, this and this wrong. Needs to change. The company says, we recognise that. We recognise that we've done the wrong thing. Let's have an enforceable undertaking to sort this out. And the enforceable undertaking is essentially private law. The enforceable undertaking is given by the company to the regulator in the full knowledge that if the company then breaches the enforceable undertaking, the regulator is going to be able to take them to task. The regulator is going to be able to say, you've now breached your undertaking, you're going to court. And the court can then impose penalties upon the company which has failed to meet its undertaking. That's awesome. Finally, we've also got injunctions. Now, we learned about injunctions last week too when we looked at equitable remedies, but the thing with injunctions when we looked at them as an equitable power is that they're really quite limited. For one thing, equity follows the law. And so if there was any chance that common law damages were going to be an acceptable way to resolve this thing if it all went pear-shaped, then an injunction wasn't going to be available. The injunction power we're talking about under the ACL, however, that's a statutory injunction power. And you see, just as equity follows the common law gives way to statute law. Statute law's at the top of the tree. And so a statutory injunction comes over the top of common law damages and over the top of any sort of equitable remedy. More to the point, injunctions under the ACL can be applied for by anyone. You don't need to be party to the contract at all. Any person can approach the court seeking an injunction. So if you're aware of a product and you're aware that this product fails to meet the requirements of the Australian consumer law, in particular, if you're aware that this product is dangerous, you're entitled to go and seek an injunction against the further sale of that product. What a fantastic power. Most of the time, of course, injunctions of this type are going to be sought by the regulator, but it does give the regulator a fantastic statutory power to use in the protection of the community. As you might be able to tell, I'm a bit of a fan of the remedies under the Australian consumer law. I think they do a fantastic job. So there we are, that's topic 11, that's the Australian consumer law and the remedies underneath it. We've looked at the fact that standard form consumer contracts, if they contain unfair terms, those unfair terms will be void. We've talked about whether they're actually void or whether they're voidable, and I'll leave you to make up your own mind on that. If the standard form consumer contract can continue to operate without that void clause, well, too easy, let it do so. However, if the removal of that void clause is going to make the entire contract inoperable, well, then the contract will be terminated. We've talked about consumer guarantees and divided them into major and minor failures. If it's a major failure, you've got the right to reject the goods or the right to obtain compensation for the difference between the value of the goods and the value that you actually paid. If it's a minor failure, then if it's a matter of title, the title should be corrected. If it's not a matter of title, then you're talking about repair, replace, or refund are really the options. The ACL, however, has a bunch of broader penalties which can be applied, or broader remedies which can be applied for when companies do the wrong thing. We've got our pecuniary penalties. We can obtain compensation for various different heads of loss and damage. The regulator can require enforceable undertakings to be given by the company. And finally, any party, any person can seek an injunction. And the court has a much broader discretion to give a statutory injunction than it would ever have under equity law. So there you go, that's remedies. And now all of a sudden we're only one lecture away from finishing our study of contract law. Next week we're going to look at something completely different. We're going to look at how contract laws operate across borders. And we're going to look at the fact that once upon a time, contracts across borders were very unusual, but now they happen just about every time someone goes online. For this point though, we've now looked at the life cycle of a contract. We've looked at its birth, we've looked at its interpretation, we've looked at its vitiation, we've looked at its termination. Now we've looked at the remedies which follow such termination, and really at this point you can now say that you understand contract law as it's applied in Australia. Next week we'll look past the border and then we'll be done. Have a great week, and I'll catch up with you one last time for Contracts B Week 12.